What rights do parents actually have when it comes to kids and transitioning? This is Xtra Explains Parental and Legal Rights. There's been plenty of talk in the news lately about parental rights, particularly when it comes to young people's gender, sexuality, pronouns, and presentation. Provinces like Alberta, Saskatchewan, and New Brunswick have gone so far as to add in new policies and laws protecting so-called parental rights, requiring schools to tell parents if a kid chooses to go by a different name or pronouns at school. But in reality, legally in Canada, parental rights don't really exist in the way that some people seem to think. While parents have an obligation to care for their kids, they don't own them and can't strip away their rights just because they're kids. In a 1995 Supreme Court decision, it was established that while parents are free to raise their children as they see fit, they are not free to violate their children's best interests. They don't have the right to override their kids' rights to security, safety, and self-determination. Legally, there's no line in the Canadian Charter of Rights and Freedoms or any legislation saying that parents have the right to stop their kid from going by they/them pronouns, or that they have a legal right to know if the kid does. All of this focus being put on parental rights is forgetting a key person in the equation: the kids. What about kids' rights? And if a young person wants to do something like transition and their parent or guardian isn't supportive, when do they have the legal right to just do it anyways? For those under the age of 18, it varies across the provinces and territories, but there's nothing in Canadian law stopping a kid from using a different name or pronoun for themselves out in the world. Now, when it comes to medical transition, most provinces require parental permission for any surgery under the age of 18. But it's also important to remember that gender-affirming surgery for people under the age of 18 doesn't really happen at all. Most prescriptions for things like puberty blockers or HRT do require some level of parental sign-off. But in Canadian common law, there's something called a mature minor. A child who's assessed by a healthcare provider as being capable of giving their own consent is classified as a mature minor. And in many provinces, mature minors can make medical decisions independent of parents or legal guardians. But even then, a mature minor is usually over the age of 14. Now, the age of majority in Canada is generally 18 or 19 years old, depending on the province or territory. And at this age, individuals are legally considered adults and can make decisions independently, including those related to gender identity and expression, like starting hormones or changing their name legally. So if a young person doesn't have affirming guardians, they are legally free to do as they wish as soon as they hit the age of majority. But it's important to remember that some US states have already made moves to restrict access to gender-affirming care for adults over the age of 18. Lawmakers in at least 4 states last year introduced bills that would prohibit people as old as 26 from receiving gender-affirming surgery or HRT. So even being an adult may not protect trans folks from facing restrictions like these. And that should make everyone who cares about people's right to bodily autonomy worry big time. For more explainers on everything you need to know about trans youth, from puberty blockers to parental rights, head to xtramagazine.com.